Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Umar Farouk bin Rohaizat, and today I'm presenting group number 1 for dispute resolution, presenting to lecturer Madam Asnalisa Arma. My group today, group number 1, are going to present about mediation. Okay, let's start with the introduction. So we all know that mediation is a part of ADR, or alternative dispute resolution. So alternative dispute resolution, or ADR, refers to an array of methods for resolving a legal dispute without resorting to the court system. ADR plays a pivotal role in the American legal process, but it's often overshadowed by Hollywood's glamorous portrayal of jury trials. One might imagine that all legal disputes are battled out in large courtrooms filled with jurors and spectators, but in reality, about 5 to 6% of civil cases ever make it into trial. So there's ADR methods typically take one of three forms: negotiation or direct negotiation, mediation, and arbitration. So these methods differ in the degree to which they involve a third party. Deciding which form is most appropriate depends largely on how well the parties get along. So I'm going to acknowledge you on the surface regarding negotiation and arbitration, because mediation part, my groupmate Naufal Jamal will cover mediation. So I'm going to on the surface acknowledge you guys about negotiation and arbitration. So negotiation, or direct negotiation, is generally defined as two or more disputing parties meeting together in good faith to identify and discuss the issues at hand, present facts and supporting data, arrive at mutual solutions, and abide by the outcome. As its definition suggests, negotiation covers a broad spectrum of avenues parties might take to reach a resolution. So the setting can be as formal or informal as the parties want. Direct negotiation is distinguishable from the other two ADR methods, from arbitration and mediation, because it does not involve a third party. Rather, here, the disputing parties work together directly to reach an understanding. So another one is about arbitration. Arbitration is the most structured of the ADR methods. In arbitration, the neutral third party, the arbitrator, conducts formal hearings, make findings or fact, and renders a final decision in the matter. Unlike in mediation, the decision is legally binding. So unless the parties have entered into a prior agreement stating otherwise, the arbitrator is often a retired judge or a panel or a panel of retired judges, given that they are experienced handling legal dispute. So procedurally, arbitration is much like trial. So the meaningful distinctions are: it is conducted in a private forum, and the parties cannot appeal the arbitrator's decision. It is absolutely final. Arbitration is most appropriate when one or more of the parties is hostile or uncooperative. It is a common forum in contract law because most commercial contracts require arbitration in the event a dispute ever arises, which is oftenly does.
Bismillahirrahmanirrahim. Hi, Assalamualaikum. My name is Muhammad Afur Jamal bin Muhammad Bismillahirrahmanirrahim. My number is DIL 2010 bin Muhammad Osman. Okay. My number is DIL 2010. Group saya pilih mediation. So saya akan terangkan tentang mediation. let's go to pilih mediation. So saya akan terangkan. Okay, mediation is a form of alternative dispute resolution which is confidentially and voluntary whereby of alternative dispute other parties which is confidentially and voluntary whereby third party by other parties discussion between the parties and impartial third party facilitate discussion between the mediator will then listen to which is called the mediator each party will then and the mediator will then make suggestions to recommendation and the mediator will to then make suggestions to recommendation to guide the parties to mediation adalah satu bentuk penyelesaian pertikaian alternatif mediation adalah satu bentuk penyelesaian pertikaian pihak alternatif melantik pihak ketiga dan sukarela yang tidak pihak berat sebelah yang melantik pihak ketiga perbincangan yang tidak berat sebelah pihak ketiga yang tidak berat perbincangan dipanggil antara pihak mediator pihak ketiga yang tidak mendengar rumutan dipanggil mediator pihak kemudiannya akan mediation mendengar rumutan kan setiap pihak dan cadangan mediation membimbing pihak-pihak mencapai membuat cadangan penyelesaian yang baik pihak-pihak mencapai voluntary penyelesaian yang baik mediation can only comment when what does voluntary mean mediation can only comment when this to make where this an agreement both parties which means to make when a party is served with an invitation to undergo mediation when a party is served with an invitation to undergo mediation is not bound to accept the other party is not bound to accept other forms of dispute resolution mechanism as compared with other forms of dispute resolution mechanism such as is bound to undergo the dispute resolution process filing bound to undergo as an agreement resolution process filing to be result as an agreement or decision apakah maksud and voluntary against them mediation hanya boleh dimulakan apabila terdapat persetujuan untuk menjadi mediation hanya boleh dimulakan apabila terdapat persetujuan untuk menjadi satu pihak disampaikan dengan kedua-dua pihak untuk menjalani apabila satu pihak disampaikan dengan tuntutan untuk menjalani pihak yang satu lagi tidak terikat untuk menerima pelawaan tersebut tidak berbanding dengan menerima pelawaan tersebut berbanding dengan adjudication pihak terikat untuk ini semua pihak terikat untuk menjalani proses ini semua pihak terikat untuk menjalani kegagalan yang boleh penyelesaian pertikaian kegagalan yang boleh dikenakan dan mengakibatkan penghakiman atau keputusan dikenakan dan dikuatkuasakan terhadap mereka.
Assalamualaikum warahmatullahi wabarakatuh and a very good day to Madam Asla. My name is Syed Abu Bakar Al-Hadi bin Syed Faisal. My metric number is DIL201075. Now my job for this presentation is to find the scene in the drama Suits, which is related to our ADR method of choice, which is mediation. Before I continue, I would like to apologize for the lack of audio in the scene I chose, so we will just have to read from the subtitles. Again, I am very sorry. Let's continue. Okay, now in this scene, we can see a mediation process in between um, Quinton, the owner of a drug company which has created a drug used to help with people who suffer from ALS, and 6 consumers of the drugs which filed complaints for the drug, and Collins, a lawyer representing the complainants. So Harvey issues a conference with the 6 of the complainants and Colin, the lawyer that represents the complainants, to propose a compensation for the side effects Quinton was unaware about, showing them a video footage of Quinton suffering from ALS. The agreement is then made that these 6 ALS patients will have partial ownership of the drug company, which will then help save lives by conducting more research for the drugs that could help others like them. Now, this is a prime example of a mediation process, a corporate mediation process in between a company and its consumers. But the same concept of mediation can also be applied to other forms of disputes, such as family disputes like divorce or even child custody. Now, that is all from my part. I would like to pass the presentation to the next presenter. Thank you very much.
Very good morning to Madam Asna and my fellow classmates. My name is Jay, metric number DIL 2010-73. So my part in this video is going to talk about the benefits of mediation on child custody. But before that, we must know what is the mediation on child custody. So child custody mediation is a process in which parents work together with the help of a neutral third-party mediator to develop a parenting plan to raise and share time with their children after divorce. The focus of custody mediation is to create a parenting plan that is the best interest of the children. Parents who mediate custody find that as a result of the techniques learned in mediation, they are more able to effectively co-parent with each other after the divorce. In fact, in many states, court-ordered mediation is a mandatory before parents can litigate their child custody issues. Even the court themselves recognize that parents and not judges are the best position to make custody decision that works for their family. Now, what is the benefit? Less overwhelming. What is the benefits of mediation on child custody? First of all, less stress for parents because mediation is not adversarial as dispute decided in the courtroom can be. The goal of mediation is for all parties to work together to come up with a solution that is right for everyone. There are no winner or losers in mediation, so the overall process is less overwhelming. A third party representative will guide the mediation process and ensure that no one's rights are violated. So you can focus on making an agreement instead of being on guard. So the second benefits of mediation on child custody is less stress for their kids. When parents are locked in a custody dispute, their animosity almost encroaches on their child well-being. Even despite the best intention, kids may feel pressured to choose sides or may hear one parent talking disparagingly about the other parents, so causing confusions and fear. Because of mediation, it's easier on parents, it's also easier on kids. They may also get an outcome that is better for them. Since the focus of everyone is in mediation is to make a plan that is right for their children. And the third benefit is improved long-term cooperation. Mediation helps to set the tone for what new normal will look like after a divorce. When parents cooperate during mediation, came up with a child custody plan, they both feel good about it. They walk away feeling encouraged about their abilities to co-parent even after divorce. This kind of cooperation sets the stage for future issues to be negotiated collaboratively rather than in an adversarial manner. So the last benefits of mediation on child custody is you are in more control. When choosing mediation over the child custody dispute tactics, you have more say in the matter. Each family is unique and have different traditions and practices. When utilizing a third-party mediator, the family needs are taken into account. Think about any special holidays, events, or activities that your family takes part in. When meditating, you can bring all this to table, finding what works best for you and your family. That's all from me. Thank you.
Hi, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon to Madam, my fellow classmate. First of all, my name is Muhammad Azim Farhan bin Zakaria, number metric DIL 20119. So today I will be taking the part of the comparison between of the mediation between in Malaysia and US, right? So in terms of the process of the mediation and why what field that we choose in the mediation that we want to discuss of, right? So the field that we choose is on the child custody of the mediation. So basically, when it comes to the mediation, so we all know that I will not explain further what is the mediation as my friend has explained what is the mediation. So we know that we notice that when it comes to the mediation of and on the child custody field, so we know that there's a mutual consent by both parties, which is the parents of the child, right? So that is why the mediation involved, right? So in general, if there's no mutual consent or one of the parties that not in agree or by any agreement, they will brought to the court. They will bring the case to the court. All right. So when it comes to the mutual consent, the mediation is involved. All right. So in Malaysia, there's process. There's a process. There's a processes of the mediation. So the first one I will explain further, which is regarding the first is the pre-mediation process. Alright, so in this process, this stage is also known as the preparatory stage. The gathering, exchange, and analysis of information are important part of this stage. So this is enable discovery and disclosure of relevant information and documents by the respective parties. So basically, the first stage is that the stage whereby the process is established and the mediator who is conduct of the mediation and the parties agree to a number of guidelines to be followed in the mediation. So this usually includes only one person is allowed to speak at a time, and then treating all parties with respect and emphasizing on the confidentiality of the process. All right. So basically, in the first stage, they will analyze. It means that uh, the the preparatory stage to go deeply into the next stage of the mediation, right? All right, so we move to the next stage. Which is the preliminary stages, which is the stage is also known as the introductory phase when mediation begins, and the mediator then makes an opening statement clarifying the role of the mediator and the parties, so explaining the process, nature, and steps of mediation. So, when it comes to this stage, it is known as the introductory phase, which is the mediator that make an opening statement clarifying the role of the mediator and the parties, and also explaining the process, nature, steps of the mediation. All right, so the second stage is the stage of exploring position and interest, where the parties usually make their initial statements regarding their disagreements and define what they hope to resolve of the mediation. All right. So basically, in this stage, in this process, the mediator is more likely they um, they are more explained what is supposed to do and what is supposed to happen. All right, in other words, it is this stage is involve the introduction in the introductory stages, which means that it means that the mediator make an opening statement, clarifying the role of the mediator and the parties, explaining the process, nature, and steps of the mediation. So basically, that is the scope of the second stages, which is the preliminary stages, which is one of the process in mediation. So when we talk about the child custody, which is involve the mediation, so we all know that the mediation, when the mediation involved, there's a mutual consent by both party. So means that the nature of the when it comes to the family matters in Malaysia, the law that is applicable is under LRA Act, which is Law Reform Act Marriage. So kalaulah anak tersebut yang adalah minor, yang umur 18 ke bawah, hak penjagaan tersebut sepatutnya diberikan kepada ibu. And apabila mereka telah mencapai umur 18 ke atas, the child itself can choose dia boleh pilih apa yang dia selesa dengan siapa yang dia mahu hidup. That is the flow when it comes to the child custody, which is the parents divorce. Alright, so maksudnya apabila mereka dah sampai 18 tahun ke atas, mereka ada hak untuk pilih dan sebagainya. So the mediation is one of the settlement, how to settle the dispute between two parties without bring to the court. Alright, so maksudnya kat Malaysia ni, dia maksudnya hak penjagaan anak ini, which is the mediation involved adalah dia nak settlement. There's a settlement to both party dengan adil dan maksudnya dengan tenang, dengan aman, maksudnya tak ada and there's any dispute ataupun tak melibatkan court pun, which is there's no disagreement by one of the parties. Okay, maksudnya tak ada ketidakkesetujuan daripada salah satu daripada parties yang terlibat. So that is why the mediation involved in this matter.
Assalamualaikum warahmatullahi wabarakatuh and selamat sejahtera to Madam Asnalisa. My name is Muhammad Ilham bin Muazmi and my metric number DIL201038. I will continue the presentation with the process of mediation based on the child custody. I will explain two process which is joint season and caucus. So in process joint season, both party will be invited to join in the discussion on custody of the children. In this case, both parties are given time to tell and provide information why they are entitled to such custody without being disturbed by other party. Each important point given by the parent will be recorded as a point to who is more qualified to take care of the child. From the process, both parties can realize who is eligible to take care of the child. In the joint season process, it is important for both parties to realize the given point that they need to get rid of ego attitude to each other. If during the process one of the party does not agree with the mediator answer, then the case cannot be resolved in this way and can only be resolved in the court. So now we move to the caucus process. In the caucus process, it is a process that is rarely carried out in mediation unless an issue cannot be resolved as both parties are tense and do not want to lose to each other. If we enter in the context of children, custody of children, this process will be carried out as a mediator giving space personally to both parties to express what is implicit in their heart about the case. the custody of the child will be exist based on the best interest of the child. In the caucus process, the two parties will meet again for a final discussion to reach a decision on custody of children and work out the detail on the agreements. So now we move to the how mediator is appointed. Let me explain appointment of mediator in Malaysia. So basically, appointment of mediator is happen when both party agrees to mediation. For example, the case ex-husband and ex-wife agree to do a mediation regarding child custody. The MMC or Malaysia Mediation Center will forward the list of mediation of the panel, and if the parties do not agree with the mediation of the MMC panel within 7 days, MMC will appoint a member of the MMC board of director as the mediator. So in making the selection, MMC will select the person it deemed most suitable to serve as a mediator. If either party have reasonable ground to object the election to the MMC and will appoint the other party. I think that's all for me. Thank you.
A very good morning to Madam and my fellow classmates. My name is Shine and my metric number is DIL201050, and today I'll be presenting about my part, which is about the mediation process in the USA. So in America, the mediation process is not governed by any official body. However, associations such as American Bar Association have set the standard for the mediation process throughout the country. Various states in the US have statutes that encourage people to try mediation as a method of dispute resolution before they enter any court proceedings. There are many processes and steps involving mediation. For example, the intake interview, the introduction stage, identifying the issues, exploring solutions, bargaining, and writing an agreement. So let's go through all of these steps one by one. In the introductory period, the media ensures both parties are present. The opening statement lays down the rules of the mediation. The mediator explains the rules and the procedure. Then the parties will state any problems that they have, and then the mediator will try to identify core problems. They'll be given an equal opportunity to express their side. Next is information gathering period. Mediator will try to form a solution with the info that he received. The next phase is problem identification. The mediator will identify the problems and then he will try to come out with proper solutions for these problems. And after completing this method, the mediator will enter the bargaining period, where he will try to make the parties agree on a deal and make the best deal that is beneficial for both parties. So let me talk about child custody mediation in the USA next. So in the process of mediation of child custody, as it is with any other mediation, it is entirely up to the parties. The mediator just acts as the middleman to ensure that the discussion happens smoothly and respectfully between the two parties. Because child custody is a very intense and very emotional situation for both parties, the mediator will try to not let the two parties become too emotional or aggressive with one another. He will try to maintain a good discussion between the two parties and find out a solution for both of them and their children. And that's all from me.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Fauzan Ibn Nazri. My metric number is DIL201035. For my part of the presentation for dispute resolution, I will be presenting about conclusion. In conclusion, mediation is an effective alternative dispute resolution that involves a process that is perfectly adapted to the parties in conflict, and in ensuring each of their needs and interests are acknowledged and addressed by a third party without any biases to either sides. It is very favorable to go to mediation to deal with disputes such as divorces or separation, This is because we can use mediation to negotiate issues with an agreement between conflicting parties that will greatly facilitate the entire process and personal situation to bring in an outcome that satisfies all parties involved.